Let's talk about trial. And in this video, I don't want to talk about trial tactics or strategies or the theoretical aspect of trial. I want to talk to you about the practicalities of the process. Once you've got 12 people in the box on a felony or 6 people in the box on a misdemeanor, what happens next? Well, the jury will get sworn in, and then the judge will ask the DA to arraign the defendant in the presence of the jury. That means basically read the formal accusation against this person. They will read through it, and then the defendant is asked to stand and asked, how do you plead to this accusation? Guilty or not guilty? At that point, the defendant should answer in a loud, clear voice, not guilty. This is not the time to be meek or soft-spoken. This is a time to sound off like you have a pair. Then the judge will ask everyone to sit down and ask the DA if they have an opening statement. The DA will give an opening statement, which is basically an outline of where they believe the case is going to go and what the evidence is going to show. Then the judge will ask defense counsel if he or she has an opening statement. Sometimes defense attorneys decide to waive their opening statement and save it for later, or they'll go ahead and give an opening statement of where they believe the evidence is going to take them and what the evidence is going to show. Then the judge will ask the state, call your first witness. And they will bring in a police officer, a detective, maybe an eyewitness. Depends on what their witness list says. They will cross-examine those witnesses through direct examination, which means they're only allowed to ask open-ended questions. Essentially, the witness is the one telling the story. Then, defense counsel is allowed to cross-examine those witnesses using leading questions, which is more where the defense attorney is sort of leading the story. They get to do this with each and every one of the state's witnesses, whether they're experts or lay witnesses. Hopefully, in the process, poking holes in the state's case, creating reasonable doubt. Then the DA will say, the prosecution rests. At that point, the jury will be excused, and defense counsel will usually ask what's called a directed verdict, essentially claiming that the DA has not proven all of their elements beyond a reasonable doubt. Usually that will get denied. Then the judge will ask if the defense has any witnesses. Remember, the defendant doesn't have to testify and doesn't have to prove anything, doesn't have to prove his innocence. The process is about the state proving the accusation they have against this individual. But sometimes the defense does have witnesses. If there are eyewitnesses who were there, who saw what happened, who can testify that he acted in self-defense, or maybe it didn't go the way the state's witnesses are saying, absolutely, those people should come forward and testify. What you cannot have is people to come in and testify to what a great guy this person is, and he is such an upstanding and moral has such upstanding and moral character that he could never do such a thing. That's character evidence. And character evidence does not come into the guilt-innocence process. That only comes in during punishment, and I'll get to that in a little bit. But the judge will then ask the defense if they're ready to move forward, and if they do have witnesses, then the jury will be brought out again, and the judge will ask the defense, call your first witness. The defense then calls their witnesses, and again, because it's direct examination, they are limited to the type of questions that they can ask. They have to be open-ended questions because they're presenting that witness. That witness then is subject to cross-examination by the DA in the form of leading question. So it's very difficult and very tricky. Then once they're done with those witnesses, there's usually a short break, and the judge will ask, is the defendant going to testify? And they can decide up until that very last minute if they're going to testify or not. Hopefully, if they have made enough progress in their defense and they have poked enough holes in the state's case, they won't have to testify. But sometimes they do. Say, for example, if they have to establish self-defense or something like that. The jury will be left out. If the person is in custody, they will walk them over to the witness stand without the jury being in the courtroom so they don't see that he's in shackles. They will be placed in the witness stand, and then the jury is brought back out. The defendant then may testify if he so chooses, but again with the same limitations. His attorney is only allowed to ask him open-ended questions. The state is allowed to ask him leading questions. So it's a very difficult process, it's a very complex process, and one should consider very seriously whether or not they want to subject themselves to something like that in their own case if they want to testify. But let's assume they do. Then the jury is excused one more time. The defendant is brought back to the defense table, and the jury is brought back out. They will be excused for a short time while the parties discuss the jury charge. What are the specific legal instructions that are going to be given to the jury in order to help them make their decision? What is the law that's going to be submitted to them? That jury charge could take 20 minutes, it could take 2 hours. It just depends on the complexity of the case. Once the jury charge is agreed to, then the jury is brought back out and the charge is read to them. After the charge is read to them, then the parties are allowed to make closing arguments. The state will usually divide up their time. They will start with a short, general closing argument, and then the defense is allowed to make their whole closing argument. Then the state is allowed to come back and usually answer to what the defense said. So keep in mind the way the process is designed to influence juries. Juries that sometimes already come into the process with preconceived notions of guilt. But who has the first word? Who has the last word? Where does the DA get to sit? Right next to the jury. Where does the defense have to sit? Away from the jury. Watch how the process works and influences the jurors. Watch their faces. How are they reacting to witnesses, etc. Once all that's done, then the case is handed over to the jury. We're there to decide guilt, innocence. That process could take as short as 15 minutes. I've literally had 15-minute not guilties. Or it could take several days. The longer that it takes, the more likely it is that a mistrial may have to be declared. Now, what happens there? Well, let's say there's 10 jurors in favor of guilt, but there are 2 jurors who are not convinced that the state has proven their case beyond a reasonable doubt, and they are at not guilty. They will send a note out to the judge to say, we're in an impasse. We cannot make a decision. We're stuck. The judge will ask them to continue deliberating. They may even submit what's called an Allen charge, which is what we refer to as a dynamite charge. It's supposed to put a fire under the butt of the jury to make a decision. But that doesn't mean that those 2 jurors that are holdouts have to change their mind. They are allowed to stick to what they believe, and they cannot be bullied into changing their minds. It has to be reasonable argument and discussion amongst the jurors. But if they cannot come to a decision and it's starting to take a day or 2 or 3 days, then the defense will likely move for a mistrial. Before the judge declares a mistrial, he has to find out if the jury is in fact hung. Is it a hung jury? Can they not make a decision? If they can't, then they will declare a mistrial, but that process could take days. At that point, the state needs to decide, do we want to re-prosecute this case or not? A lot of that depends on the split. What was the split? If it was 10-2 for guilty, chances are they're going to retry that case. But if it was 10 for not guilty and 2 for guilty, there's a good chance either they're not going to retry that case or they're going to make the defendant an offer he can't refuse. That is a process of guilt innocence. This is what they refer to in Texas as a bifurcated process, meaning that first there's guilt innocence, then there's punishment. And I'll go into punishment in a minute. I like to say it's a 3-part system where there's jury selection, then guilt innocence, and then punishment. But hopefully this helps you understand the process a little bit and what to expect. Once again, thank you for listening.